In the past hour, a judge has ruled that there was extensive phone hacking by Mirror Group newspapers between 2006 and 2011. Mr. Justice Fancourt has been passing judgment on a privacy case brought by the Duke of Sussex and others against the publisher of the Daily Mirror. He found that 15 out of 33 articles about Prince Harry were the product of phone hacking or other unlawful information gathering. Well, I've got here with me all morning our royal correspondent, of course, Laura Bundock, and media lawyer Jonathan Code. Prince Harry will be viewing this as a triumph and the potential that he could also go forward with more than 100 other articles as well, Laura.
That's right, and that's what's going to be decided at another hearing in January, I understand. So it's called a consequential hearing, but basically it means how much of the gates can be opened to bring forward extra claims. Because remember, it's not just the 4 claimants that are involved in this whole case. There were 80 in total, a huge number, with their own claims. They were sort of put on one hold. They've been sort of stayed, as it's called. Will they be unstayed? Will they be allowed to bring their cases now? Can they settle? Can Harry have more of his 147 articles heard? That's what is going to be decided at a later day. For Prince Harry, though, today is a huge day. This has been, as he has said, his life's work. He wanted to prove what the British tabloid press were up to. We know from his memoir, his own father, the King, thought it was a suicide mission trying to take on the press. I think Harry certainly, for part of it, has proved him wrong. He has proved that he was hacked into, that there was illegal behaviour taking place. Perhaps his phone wasn't hacked as much as he thought it was, but he has proven for those 33 articles involved in this case, 15 of those were written using information that had been obtained illegally, and that there were directors at Mirror Group who knew what was going on and tried to hide it as well. And I think for that part, it will be a win in the eyes of Harry.
Indeed, in a statement, he himself said this isn't just about phone hacking, this is about accountability of power. And what we saw, Jonathan, in the judgment was really sort of the higher levels, which have hitherto said we didn't know what was going on. That has been brought into the light, hasn't it?
Well, it's thumpingly brought into the light, and I think Prince Harry's put it well. Accountability of power, and that's what he set himself to do. He's taken on the whole village, the whole kingdom of Fleet Street, and it is a mighty kingdom. It's a very powerful kingdom, and one of the things one of the other calls that's going to take place now for sure is Leveson 2, because you'll remember there was supposed to be a Leveson 2. So as to holding to account these senior people, it's an absolute win. But I think we should also go back and remember how his mum lost her life. As a youngster, he lost his mum in many ways because of the intrusion of the press into her life. Now, many will say, well, she to some extent invited it, but at least as far as he's concerned, that's not the end of it. His mum was driven to her death by this very kind of activity, and so he'll feel that for her sake, as well as his wife's sake, who he'll feel has also been ill-treated by the press, this is a reckoning which he has long wanted and he has now thumpingly obtained.
All right, Jonathan, thank you very much indeed. I can just bring you a little bit more detail of that judgment that we've had handed down by Mr. Justice Fancourt within the last half an hour. It reads, I have found the Duke's case of voicemail interception and unlawful information gathering proved in part only. I found that 15 out of the 33 articles that were tried were the product of phone hacking of his mobile phone or the mobile phones of his associates, or the product of other unlawful information gathering. I consider that his phone was only hacked to a modest extent, and that this was probably carefully controlled by certain people at each newspaper. However, it did happen on occasions from about the end of 2003 to April 2009, which was the date of the last article that I examined. There was a tendency for the Duke in his evidence to assume that everything published was the product of voicemail interception because phone hacking was rife within Mirror Group at the time. But phone hacking was not the only journalistic tool at the time, and his claims in relation to the other 18 articles did not stand up to careful analysis. It goes on. There were also a number of separate invoices unconnected to published articles, which I consider to be evidence of unlawful gathering of the Duke's private information. I have accordingly awarded the Duke damages in respect of each of the articles and invoices where unlawful information gathering was proved. I have also awarded a further sum to compensate the Duke fully for the distress that he suffered as a result of the unlawful activity directed at him and those close to him.